I do see it on my side. It shows that it's recording.
Okay, very good.
Yeah,
Yeah.
I see it also.
Okay. Well, hey, Lynn, I will introduce you as a former professor, currently a professor emeritus
There you go.
from the Bowen School of Law in Little Rock. I don't know what all you do, but I just know that for me, there may be several people on this call that have no idea who you are or what
Okay.
your relationship is to landlord-tenant. But I identify you as like maybe one of the most active people in the state on landlord-tenant. So I don't know if that's accurate or not, but that's my perception. And we want to do something up here in Northwest Arkansas, but we are confused by several things. We're confused by the names of different organizations. I see a group called Arkansas Community Organizations.
Okay.
And I learned that they in turn formed a group called Arkansas Renters United.
Yep.
At least that's what I'm reading on posts that I'm reading.
Yep.
So then I know a gentleman named Neil Seeley, I
Yep.
think connected with Arkansas Renters United,
Yes.
but I don't know what their mission is. And then of course you tell us about Arkansas Strong Communities.
Arkansans for stronger communities. Yes.
Arkansans for
Stronger
Stronger
communities.
Communities. So
Yeah.
be assured, we want to understand all of this stuff because we don't want to reinvent the wheel. We don't want to duplicate effort. We want to figure out how do we leverage and maximize effort to change the laws. What we want to change laws. We want to figure out if there's a way to provide active representation for people in evictions. And we want to see if we can't do legal representation, can we help with pro se type advocacy? And certainly we want to know about what's going on with the legislature and efforts there. So Lynn, just if you would, tell us what your background is. I know you're a longtime professor at the law school at Bowen School of Law, but I don't really know what all your connection is with landlord tenant. I should say I do know that you were right in the middle of the legislative effort, I want to say a couple of years ago, when you folks almost had a bill that was going to get habitability. And a realtors association had even agreed to it, I'm told, but at some point they pulled the plug on you at the last minute or something. Maybe you can share a little bit of history with us, but I see more people connecting, which is good, because I know this topic has a lot of interest. And the fact that believe me, there's more people that will want to hear and will want to follow this conversation after today. So I appreciate you letting us record it.
Sure. I'm happy to help. That's a lot of questions, John. I'll try to get to all of them during the next hour.
Okay.
But first, I have a question for you all. Tell me your organization's name again, because my email screen is covered up. And who are you and what do you do?
Sarah, I'll let you answer that.
Well, we're the Arkansas Justice Reform Coalition. Some of the folks here, others are just other community members that we are affiliated and partner with. I see the U.S. Marshal or the Marshallese consulates offices here. I see Diva and Dudes represented a nonprofit that helps a lot of our population experiencing homelessness or on the borders. I see Yolanda Fields with the City of Fayetteville's office that helps with housing. Let's see, Melissa is with ACOM, the Marshallese community nonprofit. So Debbie Martin is also with one of our nonprofits out of Benton County that does housing. So there's a lot of interest here with lots of partner organizations that are on board to hear and talk with you. Our organization helps individuals that are criminal justice involved. And part of that is folks that are just in poverty and are on the margins or on the bubble there that we run into issues with either not being able to get into housing because they have a past history, be it evictions or credit, or they have a felon history, but especially now individuals not being able to make ends meet. And so we've partnered with different organizations to fund rent, but we will tell you that rent money and benevolent funds, funding sources are just, they've dried up. We've used it over the last several months that it's not sustainable. And so there was a lot of hope that The most recent money through Fresh Start was going to be the thing that got us to January. It ran out immediately in Northwest Arkansas. We're hearing rumor of a second fund that may come through. I will tell you, I already hear there's a waiting list for that. And there were lots of hurdles for our population up here to access those monies. So we're definitely very interested, all of us that are here, to learn what you're doing. And again, to, like what John said, to figure out how we partner all together to be stronger and help in our community.
That sounds great. I'm so glad to find out about you, your existence, and yes, I hope that we can partner. And so let me just go ahead and get started. I taught at the law school. I started out at the law school actually as the director of the law library, but after 10 years of doing that, I felt like my head was going to explode if I continued on. And they very kindly let me move over to full-time teaching. And so I taught full-time there from about 2000 till I retired, which was officially in December and unofficially in May, because I stayed on to teach part-time during the spring. My courses were most relevant to this presentation, Real Property, which is a first-year required course that is taught during the entire year. And so I've been teaching Arkansas landlord-tenant law now. I taught it for about 20 years. And during that time, I also served as a uniform law commissioner for the state of Arkansas for 8 years and served on a drafting committee that revised the Uniform Residential Landlord-Tenant Act. And it was adopted by the Uniform Law Commission in the year 2015. So I do have experience kind of at the national level looking at landlord-tenant law in all the other states. In 2012, I was appointed to the non-legislative committee for the study of landlord-tenant law. They called it the non-legislative committee because that meant it wouldn't get any money. So we worked together for a year. Most of the time we spent listening to the complaints of the people on the group who were landlords or represented landlord interests. And we kind of constructed a basic eviction procedure for them that would be fair to both landlords and tenants. The remaining part of our time was spent discussing the lack of an implied warranty of habitability in Arkansas. And I'm going to go ahead and start with my PowerPoint presentation now. So says the host disabled participant screen sharing. So I think you need to give me permission to share.
I'm making you the host so that you can screen share because it didn't give me another option. Sorry.
Oh, okay. How exciting. All right, I see it there. Okay, can you see?
Yes.
All right, great. So one of the things that our commission pointed out was that Arkansas law is different from other states in a couple of significant ways. First of all, we have no implied warranty of habitability. Those are minimum standards that a residential landlord must meet and maintain throughout a tenancy. And an implied warranty typically also contains remedies for tenants if the landlord breaches this duty. That's not the law in Arkansas. The law in Arkansas basically is that if the landlord does not promise to make repairs in the lease, then the landlord has no duty to make repairs. We have a statute that criminalizes the failure to pay rent. This is often called the criminal eviction statute, and I call it that myself sometimes. But technically, all it says is that if you are late with your rent, this statute says that you forfeit the rest of your lease term. And if a landlord decides, if your landlord decides he wants you out, he can at that point give you a 10-day notice. It doesn't allow you to cure the problem. It just says be out in 10 days. And if you're not out in 10 days, and of course we all know how hard it is to move out within 10 days. If you're not out within 10 days, then you have at that point committed a misdemeanor. Statute says it's a misdemeanor, It's not a misdemeanor, it's a criminal offense. And at that point, the landlord can go and complain to a prosecutor and have you issued a citation or a summons. If you're already in trouble for some other reason, you could actually be arrested. For example, if there's a failure to appear warrant out against you already. And then you have a plea and arraignment, and at that time, if you fail to appear, then a bench warrant will be issued against you, and there will be a bond as well. So we just have this statute that criminalizes the breach of a contract, basically, even if there has been no fraud. We are unique in that respect. And then finally, something that's been kind of brought into relief because of COVID is that our unlawful detainer statute, if the landlord pursues a writ of possession, and all landlords do. I think originally this was intended to be for emergency situations, but all landlords pursue writs of possession. And if that's the case, the tenant is sent a notice of intent to issue a writ of possession, and that requires a response within 5 days, and also requires a deposit of the rent that is alleged due into the registry of the court. It's been a couple months since I looked at Florida's statute, and I know that there's a lawsuit going on right now over its constitutionality. I think our statute is almost identical to that of Florida. If the tenant doesn't, but we're the only two states with a statute like this. And if the tenant doesn't meet these requirements, the tenant is then dispossessed without a hearing. So writ of possession is issued, sheriff's deputy comes, and you are out. We didn't talk about the unlawful detainer statute at the commission meeting. But we did talk about numbers 1 and 2 during the year that the commission met. And we issued a report with 10 unanimous recommendations. I was really surprised that they were unanimous, given that half the commission was represented landlords. We gave the report to the legislature, which ignored every single one of our recommendations. They didn't pass a single one. In 2015, about in 2013, 2014, I wrote a law review article on how unlawful the failure to vacate, how unconstitutional the failure to vacate statute was. It was unconstitutional in about 5 different ways. And a Pulaski Circuit Court ruled that it was unconstitutional, citing my article in 2015. That decision was not appealed. And so as a result, it stands only
bring my bugles back.
level. I'm the host. I don't know how I can mute everybody.
Yeah. Sarah, I see Sarah Milford's on. Okay, I think she turned it to mute.
Okay, good. Good. All right. So anyhow, we are kind of unique in our bad statutes. Commission issued a report, legislature did nothing. Every session since then, I've been involved in efforts to introduce an implied warranty of habitability bill. And in 2017, we also actually introduced the simple, fair eviction procedure. None of them have gotten anywhere. So this session, every session, however, we have more momentum. So this session, we formed a nonprofit called Arkansans for Stronger Communities. It's a 501c4, which means that we are a nonprofit, but we can spend money on lobbying, which other nonprofits are much more limited as to what they can spend on lobbying. We really don't have any limits at all. We hired a lobbying group, Capital Advisors Group, and we have drafted a package of bills, an implied warranty of habitability, a simple pro se eviction procedure. This is basically our procedure from 2017. amendments to the unlawful detainer statute to increase the 5-day response period and to end the initial deposit requirement, which the legislature only added in 2007. It hasn't been around for that long of a time. And then finally to repeal the criminal eviction statute. So we have a lobbying firm working for us. We have a whole bunch of partner groups, which I'll show you at the end of the presentation. Americans for Prosperity is one of our partners, and they are lobbying as well. Arkansas Advocates for Children and Families is one of our partners, and they are lobbying for us as well, although we're kind of further down on their list. So that is what is going on right now. Another thing that I do is I've read every single eviction case in Arkansas since the end of March. You might ask why I have done this. In March, our governor was at one of his early press conferences talking about COVID, and he was asked whether he was going to declare a moratorium on evictions. And at that time, he said that he thought that landlords would be accommodating to tenants and there would be no need for such a moratorium. And I wondered whether that would indeed be the case. And so I decided to start tracking evictions. And so I've done that since the end of March. And I publish a monthly report about evictions, which some of you may have seen. I know John has seen it because I've sent him a couple of them. And so as a result, I can talk to you about evictions and what's going on across the state, because I look at every case that appears on Court Connect to see if it is a non-payment of rent case or not. And then as long as there's a landlord-tenant eviction or tenant relationship, because not all unlawful detainer cases are landlord cases. Some of them involve different relationships between two people, but it's not a landlord-tenant relationship. So if it is, then I track it. And so I can tell you what's been happening with evictions. And this is a demonstration in front of the Pulaski County Courthouse back in October by the Arkansas Renter United folks. And I can tell you about that group as well. In fact, I just was texting with Neil right before this presentation. So what's been happening with evictions during the COVID pandemic? Eviction filings, and we have 3 types of evictions in Arkansas. We have unlawful detainer. That's the one that's filed most often, and that's the one that is filed in circuit court. And then we have 2 other procedures that may or may not be filed where you are in your counties, and they are filed in district court. One is the failure to vacate statute. It's my guess that fewer than 30% of the district courts even hear these cases. And the only district courts that seem to be hearing numbers of them are in Fort Smith, Texarkana, and Hot Springs. In other places, there may be a handful of cases heard. Springdale used to hear a lot, but I don't think Springdale hears any anymore. And I think the court case, the Pulaski County court case, had a big effect. Little Rock used to hear hundreds of those a year. It heard more than any other court, and it now hears none. The prosecutor will not accept those cases. And then the third kind of eviction is what I call the 2007 Act eviction. You can read it at Arkansas Code Annotated 18-17901 at SEC. It didn't exist before 2007. The legislature enacted it then. It's heard by district courts. They actually have no jurisdiction to hear these cases. It's unconstitutional for them to hear the cases, but some of them do. So some courts are hearing these cases around the state. No one in Pulaski County hears them. I don't know about Washington County, whether that's the case. So when I get done, you guys can tell me whether anybody up in Northwest Arkansas hears those cases. So I look at all of these that appear on Court Connect. And not all of them do, because a lot of failure to vacate cases don't appear on Court Connect because not all district courts are covered. A lot of 2000 Act cases don't appear on Court Connect because not all district courts are covered. But I do look at the 3 types that I can find on Court Connect. All of the unlawful detainer cases appear, so I am monitoring all of those. They dropped off sharply in March, as you would imagine, because COVID started to hit and we had all of these restrictions in our state and everybody was taking the pandemic very seriously and people were losing their jobs at a very quick, high rate. But then they started to creep back up. And so there were sharp surges in August when the CARES Act moratorium ended, in September. And for September, October, and November, evictions are basically at the same rate that they were last year. So we've returned to our normal rate. But what is different is that we're now in the middle of a pandemic. So tenants received stimulus checks back in the spring. They received increased unemployment insurance payment amounts and an extended period of unemployment insurance eligibility. And we had the PUA for people who previously were ineligible for unemployment at all. There was first the CARES Act moratorium that covered, quote, covered housing, unquote. And after that, we had the CDC moratorium that started in September for covered tenants. But all those are coming to an end at the end of December. And so if we don't see something coming through from somewhere, oh, and Arkansas also awarded, Arkansas was awarding money through ESG and CSBG, that should read, not CDBG.
Lynn, let me interrupt you just a moment. There's someone trying to get in, and I think since you're host, you have to let them in.
Oh, okay. I don't see them now. So, oh, wait,
Monique?
wait. Oh,
Monique?
okay. Okay, I've just admitted all of them.
Okay, good.
No, sorry about that. Actually, there's still one more person coming in, but I don't think they're in. I guess they are. Okay. All right. I apologize. I'm looking at my PowerPoints and I'm a little distracted here. So just let me know if anybody else shows up late. Anyway, Arkansas was awarding little streams of money coming through ESG and CSBG that almost no one was eligible for except the very, very poorest of tenants. And then there were limits put on, like Pulaski County would only give $500. That's probably not even going to pay 1 month's rent. And so Arkansas came up with 10 million in rent assistance in October. That started being, you could apply for it starting the first week of November. I think that there's a kind of a backlog of people getting approved. It's my understanding that caseworkers are assigned to each one of these applicants. And I've got some statistics on this at the end. But it's going slowly and basically all the money has been spent now. So you mentioned at the beginning that there seems to be a little bit more money possibly this month, and I'd like to hear about that. The first I heard about it was today, talking to somebody up in Fayetteville, as a matter of fact. And I am gonna get with Terry Bearden and ask her about the availability of extra money. So how is it for these tenants that get sued in eviction in circuit court? Almost, and there should be an all in there, almost all, whoops, almost all landlords are represented by tenants, represented by attorneys in circuit court in unlawful detainer cases. It's rare that I find a pro se landlord in these cases. On the other hand, almost no tenants are represented by attorneys. And almost no tenants, well, few tenants, most tenants, don't ever file a response. That's because you've got to file a response in 5 days and you've got to pay a deposit into the court. Now that's actually not what's happening right now, but that's what the paperwork tells tenants they have to do. So even though that's not what the courts are actually doing, and I'll talk about that in a minute, the tenants don't know that. The paperwork doesn't tell them that. So in September, tenants filed responses in only 17% of unlawful detainer cases. In October, 27%. I think the rise came from the CDC moratorium and the fact that they could now file a CDC declaration. In November, 20%. In September, 3% of tenants being sued were represented by attorneys. In October, 4%, and in November, 5%. I think the numbers are rising because of the CDC moratorium. But you have this real inequality of representation here. Almost all landlords, almost no tenants. And of the tenants that are represented, almost all are by legal services attorneys, except for John Comstock and a couple of other attorneys out there. So what has been happening with evictions since the CDC moratorium began in September? From responses, it seems to me that some tenants are unaware that the moratorium is even in place. They in their response, explain facts about themselves that, or allegations that would seem to put them squarely under the coverage of the CDC moratorium, but they haven't filed a declaration. They don't say that they have, they don't file one with their paperwork. And so it seems to me that they're unaware that this moratorium even exists. That, of course, is unfortunate. Sometimes their allegations will get them a hearing. Sometimes they even may win in court, but most of the time they're not going to. Something else that I've seen is that tenants are unaware of the declaration form. They discuss the moratorium in their response, but they do not state that they gave a declaration to their landlord, and they do not file one with the court. Tenants file after the writ of possession is issued or served. They're usually not going to win in this situation. If they have an attorney representing them, their chances are much better. But tenants file the declaration early, but they don't pay any money into the court registry. This usually will be okay. It won't hurt them unless they wind up in the courtroom of certain judges. What I'm seeing in tenant responses is that there are landlords who don't accept the CDC form. One landlord said, "It doesn't apply to this property." I'm not sure what he was thinking about, but it applies to any property. The question is whether the tenant is covered by the CDC declaration, whether the tenant meets the conditions, not whether the property meets the conditions. Landlords are not accepting rent assistance. There were several instances that the tenants talked of this month in their responses and in previous months. And talking to Terry Bearden at the Arkansas Community Agencies Association office, she is telling of instances where tenants call them and say that the landlord won't accept rent assistance. The rent assistance from the ACAAA, from the community action agencies, goes directly to the landlords, and the landlords have to sign an agreement that they're not going to evict the tenant, that they won't charge late fees, and some landlords are unwilling to do that. It's my understanding that they also have to give some tax information to the community action agencies, and some landlords refuse to do that, I think because they are not counting their rent as income. So they don't want to do that. Some landlords won't accept partial rent payments from tenants. Tenants run into several months of bad luck. They don't have a job. They don't have a car. Their kids are home from school and they don't have babysitters. You know, you are hearing the stories of these folks, so you know what they're going through. And they try to make partial rent payments to their landlords, but their landlords won't accept the rent payments. Or the landlords start stacking the penalty fees and late fees on, and they won't accept a payment of just the regular rent, because now that's only partial rent, because now they're, you know, the actual charge that they have to pay has been doubled. And since the CDC moratorium only applies for non-payment of rent evictions, what I expected to see was that landlords would start to evict tenants on pretexts. And that is indeed what I have seen some evidence of. My favorite was the landlord who, in the complaint, said that the tenant had handed in a CDC form, but they were evicting this tenant because the tenant had failed an inspection of the rental premises. And the tenants replied, and they said that everything was great with their landlord until they gave their landlord a CDC declaration. And then their landlord showed up for an inspection when they weren't home. Their adolescent daughter was home, and she had just apparently gotten out of the shower when 3 strange men walked into the rental unit without knocking. They just came in to perform the inspection. And when the landlord gave the inspection form to the tenant to sign, all it said was, your air filter is dirty. But when the landlord turned in the inspection form to the court, all sorts of other things have been added to it. The air conditioning unit was broken. Sorry, I had to admit somebody there. The license plates on the tenant's car weren't current. That was a new one on me. I didn't know that you could put that in a lease. All sorts of other things had been added on. So that's kind of an example of evicting somebody on a pretext. So how are the courts handling cases post-moratorium? Well, that shouldn't really even say post, it should say during the CDC moratorium. During the CARES moratorium, the Arkansas Supreme Court issued an order, and it required landlords to plead that their property was not covered by the CARES moratorium. Most landlords followed that order. The Supreme Court could have issued an order dealing with the CDC moratorium, but it didn't. It chose not to do that. And so as a result, there's no uniformity as to how courts are handling these cases across the state. There is a spectrum of responses. And it typically is going to depend, how a particular case turns out is going to depend on, 1, how the judge handles these cases, and 2, what actions the tenant took after they were sued. Those are the 2 variables that you need to look at. So how are the courts handling these evictions? Remember that our law requires tenants to respond within 5 days and deposit rent with the court. A handful of judges are going ahead and ordering a hearing even if the tenant does not file a response at all. And 1 Northwest Arkansas judge is doing this, and 1 Central Arkansas judge is doing this. And it's my belief, well, for one of the judges, I'm pretty sure I know because he wrote about it on his Facebook page, but this is in response to the pandemic. And I assume that it is that way in the case of the Northwest Arkansas judge as well. So this is the best case scenario for you if you're a tenant to end up in the court of one of these judges. Many judges—
Can you tell us who they are?
I'm being recorded, right?
Oh, that's all right. Okay, you can tell us later.
I'll tell you later.
Okay.
A handful of judges will order a hearing. Sorry, not a handful, many judges. In fact, this is the most common judicial response. If the tenant files a response, even if it's not timely, and even if they don't pay the deposit, the judge will order a hearing. So you can file your response late. and not pay the deposit, and you'll get a hearing. How many tenants do pay the deposit? Almost none. It's getting a little more common. I think this month I maybe saw 5 tenants who filed a deposit, but there's never more than a handful each month. One judge in Little Rock requires landlords to aver, either in their pleading or in an affidavit, that they have not received a CDC declaration from the tenant. I think this is a good response as well, because the landlord could be subject to sanctions if this turns out not to be true. Some attorneys, a lot of attorneys for landlords in Northwest Arkansas already put that information in their pleadings, I've noticed. And then a handful of judges, there's one up here and there's one down in Little Rock, order a writ of possession to be issued by the clerk unless the response is timely and the deposit is paid. This is the worst type of judge. You don't want to wind up in these judges' court. So let's say that the tenant has filed a CDC declaration. What typically happens? If the landlord files the declaration within 5 days, most courts are setting the hearing before the end of December. A few are waiting until after the moratorium ends to set the hearing. Again, even if the declaration is filed late, if it's filed before the writ is issued, most courts will set a hearing date. I think a senator is joining us, so I need to be really, really careful about what I say now. That was a joke.
The friendly senator.
A very friendly senator, yes, yes. I wish he was my senator. Several courts have set aside writs of possession if the declaration is filed late. Others have not. Your best chance is to file that declaration early in the process. 1 or 2 judges seem to ignore the declaration entirely. I don't know if they believe that that federal law doesn't preempt state law. I don't know what the reasoning is. But so far, the writs have not been issued. I think there may actually have been one case where the tenant actually was evicted, but in almost all of them, they order that the writ be issued, but then the clerk is not issuing the writ. And I don't know why that is. If that's a decision on the part of the clerk, or if the judge is saying, well, I'm going to order you to issue a writ here, but don't issue it. I don't know if the landlord has to pay at that point for the writ actually to be issued, but these cases seem to be stopping at that point. I think this is a violation of the CDC moratorium to order that a writ be issued. I think that is proceeding too far along the path of eviction, and that violates the moratorium. That's my own personal opinion. It's clear, though, from all these cases that the tenants who do the best are the tenants who have counsel. That's not a guarantee that they're going to win, but it almost always buys them more time, which can be very helpful to you if you're a tenant trying to move out. It may be saving them from some financial liability as well. That's harder to say, but definitely tenants have more success if they have counsel. So in terms of rent assistance, and this is coming from Terry Bearden at the ACAA, as of 11/20, there were 7,500 requests for applications from Fresh Start. 6,000 applications had actually been submitted. And there were 1,500 applicants on the wait list. These were all people in various stages of the process. As of today, I checked on their website, only 4 out of 15 community action agencies are still accepting applications for rent assistance, and none of those are in your neck of the woods. So the money is going to be gone by the end of the year, clearly. These numbers come from a US Census Pulse survey, which some of you may be familiar with, and this is from November 18th, which is the latest date. Approximately 14% of Arkansas renter households are not current on the rent. 17% of those have zero confidence that they can pay next month's rent, and 51% of those think that they're going to be evicted within 60 days. So I keep saying that there's going to be a crisis ahead, and then something happens like the CDC moratorium, and the crisis is temporarily averted. But right now we are at last year's eviction levels, and our unemployment rate is down, was down in October, but if you've been watching the news, you'll see that job growth was sluggish in November, and it was the least job growth of any month since the summer. A lot of landlords, I think, are working with their tenants. A lot of landlords are, but not all. And our eviction levels are already at last year's levels. So what happens in January if we don't have federal assistance? It is now looking like Congress is going to do something before January, which would truly be great. Arkansas's money is gone. The moratorium will end. I'm hearing that the moratorium continuing on is part of this relief package of Congress. I'm hoping that that's the case. But, you know, hopefully we're going to avert a crisis. But if we don't do anything, yes, there's definitely a crisis ahead. So Arkansans for Stronger Communities was formed in October, and our purposes are to educate the public and to advocate. So we are a 501c4 corporation. Our narrow purpose is fair landlord-tenant law, but our broader purpose is economic, civic, social, and environmental issues that affect communities. Because we are a C4, our donations are not tax deductible. And today we received permission from the Secretary of State to solicit. So I'm soliciting. And you can go to arcstrongcommunities.com. Again, we're not tax deductible, unfortunately, but we are spending every penny on education and advocacy. This is our front page of our website, and the entire website plus the donate page should be live this week. The front page is live now. And here are some of our partners. So you can see we've got a pretty broad spectrum here of folks. I think we may be adding a couple of new partners after some conversations I had today with folks up in your neck of the woods. And our website is going to have a page where you can sign up to help us. If you're an organization that wants to partner with us, we will put your name or your logo on our website, and we'll be asking you if we can communicate with you once the session starts for help, grassroots help contacting legislators. And there's just some additional information for you. There was a ProPublica article published in October about our failure to vacate statute. It's an excellent article. They interviewed a deputy prosecutor in Garland County who told them that he thought that the statute was really unfair and a bad statute, and as a result, he was fired. So this is a ProPublica article about his, or it's an Arkansas Times article about his firing. ProPublica covered it as well. And just for more information, you already know about Fresh Start. This is a talk I've given to a bunch of other people. Arkansas Renters United let me say a couple words about them. They are a tenant organization. Neil Seeley founded them. Arkansas Community Organizations is a 501c3. Arkansas Community Institute is the connected entity that is the 501c4. And Neil, through them, founded Arkansas Renters United, which is a great group. It's been around now for 2 years. They have done a lot of things. They actually went and demonstrated at the Arkansas Realtors Association annual meeting, which was in Memphis at the time. They've done a lot of activities, and they came to the legislative hearings in 2019. Legal Services Helpline, the legal services folks are great. I'm sure you know all about them. And that's basically the end of the presentation. So I'm gonna stop sharing. You'll have the recording so you can see these screens later if you want. And just ask whether you all have any questions. I see some chat.
Is the PowerPoint available?
I can send you the PowerPoint in PDF. Did you ask that, John?
I did.
I'll send it to you.
Okay, thank you.
And you can distribute it if you
And could you
choose.
send us, if it's not too hard, I think I know the attorneys particularly, but even the non-attorneys, I'd like to see your Pulaski Circuit Court decision. Because that seems like, even though it didn't get appealed, but it seems like it stopped Little Rock from filing those criminal cases. We're not faced with that right now, but I would still like to read that if you could.
Sure. Well, and it caused the legislature to amend the statute too and roll it back to pre-2001. So the statute's not the same statute anymore.
Okay. So they
But in the
modified.
ProPublica article, they interviewed Judge Herb Wright, who wrote that opinion. And he said, in my opinion, the statute is just as unconstitutional today as it was back then, which I thought that was a very interesting remark that he made. I personally also believe that our current statute is still unconstitutional. Let me take a look at these chat questions. I'll get that decision to you. It is on Westlaw, if you have Westlaw access, but you may not, so I'll get it to you. It's State versus Artoria Smith. Let's see, with a few judges sua sponte ordering hearings, are there any judges or jurisdictions that are allowing the 5-day time period for a response to be told that we see time periods told due to COVID in many other situations? Well, they're not saying that formally, but I think that's what they're doing. Some judges, a few judges aren't, but most judges are.
Have you, Lynn, have you seen any attorneys make that argument though?
I haven't.
Okay. I'm just curious if judges would consider it. I am seeing that argument being made elsewhere, both in civil procedure and criminal law. So I'm curious if you find that to be a plausible strategy if somebody were to, okay.
I would definitely make that argument. I think, this is just my personal opinion, I think that a lot of the judges, I don't want to second guess judges, but it seems to me that the judges are aware that our statute in the time of COVID is particularly unfair to tenants who through no fault of their own can pay their rent, can't pay their rent. This is a really unusual situation that we have here. So many people have lost jobs, lost hours, can't work for various reasons. I'm starting to read responses from tenants now that talk about multiple quarantines that their kids have been put through. So, like their kids have been home twice for long periods of time, or they're at home for a really long quarantine period. So these are just really unusual times. But I would make that argument. Let's see, tenants have more success if they have counsel, but under the abominable state of Arkansas law, frequently counsel must decline because there's no good faith to oppose an eviction. Yep, that's right. Hi, Lucas.
Unmute. May I speak?
Sure.
On that
Yeah,
point,
this is
so I've
Q&A.
had a lot of referrals to me from legal aid in private practice about, tenants who are facing eviction.
Yeah,
And, I looked the files over and realized, under Rule 11, I can't make a good faith pleading that, I could just file some garbage to maybe slow up the works a little bit, but that's just not good practice. And so, when we talk about, tenants needing counsel, I think there's probably a lot of other attorneys like me who are looking over these files and realize there's just nothing I can do right now.
Let me-
At the end of the
Let me
day,
offer one thing, Lucas, when you say looking over a file, I'm not sure what you mean. Does legal aid hand you a file that you're able to just review? What is it you're actually reviewing when you say a file?
I'm talking about meeting with a client, John.
Oh, okay, good. Because I was going to say, what I have found is the in-depth interview with the client is the single most important thing. And I'm not, I've been lucky a couple times because I have filed common law fraud counterclaims based on the theory that the house was uninhabitable and the tenant kept paying rent over a period of 3 or 4 months. And I interviewed the tenant, and the tenant was telling me that the landlord said they were going to fix it. They were going to fix it, but they didn't. So I took that to be a misrepresentation of a material fact and filed a counterclaim. I did that just the other day in a case where somebody's like 3 months behind on rent. They were a pro se landlord, which I'd never seen before either. And the next day, they hired an attorney, and the attorney called me and said, John, we're agreeable to dismiss our lawsuit if you'll dismiss your counterclaim, which we did.
Well, sometimes, John, we can find those facts. And when we do, we can make hay out of it, right? And we can file counterclaims and slow the process up. I'm talking about a straight up case where, we have no warranty of habitability in the state of our current law. We have a tenant who hasn't paid rent. What can you do? And we talk about, attorneys who are not taking on these cases. Maybe we're just looking over them and seeing, like Lyn has pointed out, the law is a mess. And speaking of the law being a mess, I just wanted to make one more point before I kind of sign off here. I think the realtors need to get on board with this too, because I've been on the flip side of the coin a few times where I've been asked to evict. And I look over the statutes and I think, you've got an unlawful detainer statute. You've got a weird criminal statute. You've got an Arkansas residential a statute that's dated several years ago that tried to vest jurisdiction in district courts and failed. It's just a hot mess. So politically, I would hope the realtors would be on board with, let's just fix this hot mess of Arkansas law about eviction. I'm not pushing in that direction, of course, but it just seems natural. So I'll shut up.
My concern with this conversation, because I understand the ethical obligations that an attorney has, but is there an argument or a consensus or even a movement amongst attorneys that filing an answer and contesting these unlawful detainer or writ of possession actions is somehow unethical? I mean, it's common for attorneys in civil practice to deny something and require the plaintiff to carry their burden. So I guess I'm just concerned if there's a sense or wondering if there's some sort of ethical guidance out there telling attorneys they shouldn't be involved in these unless they have great facts.
That's a really good question, Matt. I think Lucas's question was really good as well. Just a couple of thoughts that I have. Having done very little practice of law, I'm not going to go to the ethics of your question as to whether you can force the landlord to plead their case. I don't know the answer to that offhand. I do think that there are issues if the landlord has promised in the lease to repair, and most leases that I've looked at, and I started to try to look at them all, but I just really ran out of time. Just reading the cases was all I had time for. But I was seeing that most leases did actually promise repair by the landlord. And so then you have an issue. You have an issue if repairs have not been made, and the landlord is trying to evict the tenant. You have an argument there that you can make. And of course, the CDC moratorium. If the tenant's facts fit under the moratorium, well then, there's your case right there. Whether they have filed a declaration or not, I would argue you can go in there and argue those facts to the judge, and get that tenant to file a declaration as quickly as possible.
Lynn, I would say this. I've actually done several of these. I've never had to, one time I had to go in front of the judge. What happens is, at a minimum, you can file even a pro se if you want to, but file a general denial answer. And what does that do? You send that to the landlord's attorney, and you get on the phone, you call the landlord's attorney, and you negotiate an outcome. And that outcome may be keeping the tenant in there for 30 or 45 more days. That's what I've negotiated several times, is where tenants are going to leave in 2 months, 3 months, 4 months. But we get the
comfortable doing that under Rule 11?
I'm totally comfortable doing it under Rule 11.
I am too, particularly in a response situation. And to John's point, like, you can negotiate better outcome just by doing so, including some of the collateral consequences that come from having evictions.
I've never had a landlord's attorney even begin to get hostile with me as a result of filing it. The response has always been, John, let's see if we can work this out.
In the time being of the essence as we're coming upon 7, I appreciate us talking on the attorney level, but I would love to also direct the nonprofits that are on here that have clients that are facing evictions. What would you, Lynn, tell folks is kind of the next step of what they can do as far as if we're looking at needing more funding to support our clients, the rules not being in their favor? What should folks be working on? Like, how can we advocate to the best of our ability in Northwest Arkansas?
That's a really great question. Before I answer that, let me just go through the rest of these chats. And I think we've pretty much talked about all of those. Greg, I would like to be in line to be cloned after you get cloned. I think you should be cloned first. And probably everybody on this Zoom call should be cloned as well, frankly, because there are not enough of people doing this kind of work. Okay. If I had a tenant come in, there's things. I mean, first figure out what their problem is. Sources of rent assistance, unfortunately, you all are going to know more about that than me. Right now, it seems like they are pretty much tapped out everywhere. But it's looking like we may get something new coming along here pretty quickly from Congress. I really hope that that's the case. As far as legal help goes, they should contact legal services. Legal services, if they qualify for legal services, then they will get assistance from a legal services attorney. Even if they don't qualify, they may be able to get some general information from legal services that can help them.
I think some of our concern was that given the quantity of individuals that are currently needing assistance, I mean, I'm seeing like 10 plus a day between postings online and like people we're running into, which is way over what we've seen in the past, is they already have had to wait with those organizations like legal aid, and being concerned with the timeliness and their staff not being able to take the mountain of individuals we're going to send their way.
Okay. I've been talking to legal services attorneys pretty regularly, and I don't get I'm not hearing from them that they're having mountains of individuals come to them. So I'm hearing from them that they've been pretty much able so far, and they have the ability to contract with pro bono attorneys. So I wouldn't hesitate to send people to them. And they also have some really pretty good general information on their website that people can look at. You know, what Arkansas could really use is some pro bono attorneys handling these cases. John, like you are doing, and apparently a few other people are doing up there with you. I don't know of anybody in Central Arkansas that is organizing to do this. I see the names of some attorneys that I know occasionally representing a tenant or two, but I don't think that anybody is talking about this like you are. And kind of early on, I approached legal services with this idea. And maybe I was kind of ahead of my time, but maybe, you know, maybe now is the time to revisit this idea, because I do think there's a need for pro bono attorneys helping folks right now. John had asked me if there was grant money available for that. I do not know the answer to that question. But I would talk to legal services about that, because they may be aware of something. There's a question here in chat. If the tenant is behind by hundreds of thousands of dollars, they can't catch up with or without lawyers. There are oftentimes if the tenant has somewhere else to go and the tenant wants to leave and the landlord wants them to be gone, the landlord will let the tenant go without seeking the money. Sometimes it's possible for a settlement to be reached. And I think John has described instances of himself doing that with landlords. So, you know, if you have a situation where a tenant is living in a really substandard place and the landlord had promised in the lease to make repairs, I would say that situation is ripe for some kind of a deal to be made so that the tenant won't have to pay everything that they owe the landlord, because the landlord has owed them good repair and the landlord hasn't been making it. The website I cited is the legal services website. I would Google legal services, landlord tenant law, and you probably will be able to get to it that way. But they have a lot of information posted for folks about all sorts of legal problems. Let's see. Okay, www.ourlegalservices.org. Arkansas Fresh Start has a waiting list. Yes, they sure do. And I think at this point, you're probably not going to be able to get, you're not even going to be able to apply in most places, let alone get on a waiting list, unless you're in Northeast Arkansas. That's where they still have some money.
Lyn, are you hearing anything, or I guess is your organization looking at too? One of the issues we've run into, especially in Northwest Arkansas, we have the largest population of, you know, Marshallese outside of the Marshall Islands, and we run into issues with paperwork and translators being available to really speak with this community has been hard hit by COVID, as well as we have refugee resettlement here as well. And while they have their services, we've resettled quite a lot of families in a short period of time lately. And so they often need assistance as well. And so I'm just curious on any of the materials being like translated to be helpful, or if there are services specifically for these maybe different cultures that are outside of just the average Arkansan.
That is a wonderful question, an excellent question. And the last time I talked to Terry Bearden, I asked her if the Fresh Start materials were being translated into Marshallese. And she said she didn't know and she would look into it. And she will, I'm sure she already has looked into it. As far as legal services go, I don't know. But next time I talk to them, I'll ask them. And I talk to them all the time. So, you know, I just don't know. It's not a question that has come to me. So So I haven't checked on it, but I will.
Okay, thank you.
Sure. If these materials haven't been translated, is there a way to get them translated? What would that way be?
I'll open the floor to others that are in attendance because we have some folks from our Marshallese community. I always am looking too to see if there's a way. I know these folks are incredibly busy, and so I don't know if there's a way to compensate for that translation services, if that would be done through like the state of Arkansas, if there would be a funding source for that. But I know that they
Maybe
all have,
legal services,
I'm sorry.
or maybe legal services, if you're talking about translating their own material,
Sure,
you have the money to do that.
sure.
Anybody want to speak to that? How we would get translations of general information for tenants made into Marshallese?
Hey, Lynn, this is Melissa from the
Hey,
Marshallese
Melissa.
Coalition. Hey, I think instead of reinventing the wheel, look at resources that are already working on, Marshallese translation, especially Legal Aid of Arkansas. They have done a lot of translation on things like that. So you might want to check them out to see what kind of resources they have. I know, one of the things that I always ask is ensuring that our partners or, folks that want us to translate materials, they also respect our time by considering, it doesn't have to be a huge budget, but it could be, something because, that's translation is not easy. So it takes a lot of a lot of work. So you might want to look at Legal Aid of Arkansas, and I'd actually mentioned some other resources to Sarah and John Comstock, and hopefully they're looking into those resources and to see if there's a possibility of funding coming from their end. In terms of legal service, I know Sarah brought that up, and we're seeing a lot of, and these are not new issues, but I feel like the issue is way bigger, and certainly changing some legislation to where tenants have more right would help a lot. But there are cases where, we have someone who's been paying rent for years and then just 1 month late, and then they get eviction notice. So those kind of stuff. But the process is when we refer people to few other resources that we have. For example, legal service has really worked with us for a long time. Actually, they're one of our partners and friends. But there are some times that maybe the response won't be that quick. And in other words, there are more cases that we're seeing coming in. So that could possibly cause that tenant to actually move out. And you have to really understand the culture. It's almost like you have to live in it to believe it. You have to really kind of, for the most part, when you're talking about legal process, that's a very scary, just simply filing response or things like that. It's a heavy responsibility to a person who is an immigrant in general, who just moved to the United States and trying to navigate the system. So I think considering those needs is very important. Otherwise, we're not going to have, things are not going to be equitable. So I do think I've proposed this before. The 501c4, it's certainly it's a good thing that we're having, but I also want to see, it's even possible. And I know there are many of you attorneys that are sitting here looking at something, maybe some kind of a tenant association in their area. So it might be off chain and crazy, but I just think that sometimes certain groups need more help and need more guidance, especially navigating the legal system. I'll be quiet.
Thank you, Melissa. Has anybody here talked to Neil Seeley about getting Arkansas Renters United up in your neck of the woods? Okay. Well, I texted him before this meeting and I said that we were probably going to be talking about this topic and said, what would you need to get Arkansas Renters United up there? And he said that he is hiring an organizer. And he said he would be glad to come up there physically for a meeting if there can be a safe space in which to meet. So, you know, you all would know the answer to that better than I. Sarah, do you want me to send you his contact information? I'll just send an email to both of you so you have each other's contact information and then you can get in touch. I thought he said he had been on like an email with you about something, but no?
It's possible, I'm not sure.
Okay. All right, well, he's very interested in making this organization statewide, and it's done good work so far. So, you know, and I know he's been out to the Fort Smith area. So, that was probably pre-COVID. So let's work on getting some ties up there, up in your neck of the woods. That would be great. And I also want to say that I've given presentations to you all and also to COC, and I'm embarrassed to say, I forget what that stands for, but I know they're folks that work with housing and some of them are here tonight on this presentation as well. And I just want to compliment you on how great it is that you all have come together and you have these groups that are working together in a common cause. And I just don't see as much of that down in Central Arkansas, and I wish I did. But you know, kudos to you for doing this. Yes, continuum of care. Thank you. All right. Anybody have any other questions? And John, I'm sure you and I are going to talk this week. I'm going to call you because I have a question that I want to ask you, and I'm sure you know what it is, but I'm hoping we can talk a little bit this week. So, you know, and if you have any questions, just shoot me an email. And, you know, good luck, everybody, and Godspeed in the work you're doing. It's really good.
Lynn, you met all my expectations. You exceeded them. So
good.
Yes, you did. Absolutely.
Excellent.
It was an excellent presentation as far as I'm concerned. And I love the wide breadth of people that you just acknowledged that are attending this session. It shows you that there's just so much urgency out there. We just don't know how to leverage all of our resources to do something effective about this. And to Lucas's point, you know, what do we do with that tenant that doesn't have a good defense? How can we still give that person relief? That's what we want to do.
Well, it sounds to me like you've definitely had some success in your cases, John. So, you know,
Handful.
I love to hear about your strategies and, you know, that 30-day eviction period too. You know, spread the word on that up there. Legal Services is using that. And let me just say very briefly what that is. The CARES Act, a little tiny part of the CARES Act carried on after the moratorium was over. And that little part of the CARES Act that has carried on basically states that if the property is a CARES property, then the landlord has to give the tenant 30 days notice before filing an eviction action. They can file, but they have to give 30 days notice. And Legal Services seem to be the only folks who are aware of this and are using it in their court cases.
Well, Lynn,
yeah.
During the presentation tonight, I apologize if somebody saw me on my phone. I texted a landlord and told her I was on a Zoom call dealing with landlord-tenant and said, I've just learned that the CARES Act requires a 30-day notice to evict, because she was wanting to give an eviction notice tomorrow based on 3 days past due rent.
Well, our unlawful detainer statute says 3 days is the notice period. But now, is it a CARES property?
Oh, okay, you know what? I may have misspoke because I got crosswired. I was thinking, I forgot, you told us under the CDC, it doesn't matter what the property
Right.
is. But the CARES Act still has to be a CARES property.
Yeah,
Okay.
which means that it has to be associated in some way with the federal government, you know, like it's under a mortgage that Freddie Mae or Freddie Mac or Fannie Mae subsidized, you know, some connection with the federal government. Yeah, and that's another thing. Not only is our law a hot mess, it's also incredibly complicated. And it's really, you know, there may be things that you can do, but you just don't know about them.
Yeah.
It's unfortunate. So anyway, anything else from anybody? Okay, well, thanks for inviting me to speak. I really appreciate you guys.